Discharge of a contract means that the contract has been concluded and the obligations between the parties have been discharged. So, of course, the contract, once it is made, also has to conclude, and it has to end at some point of time. Now, we will notice that the term discharge of a contract comes from the fact that the law says that once an obligation has been entered by both the parties, it will probably end at certain point of time. However, you will notice that today the parties themselves would decide what we call in contracts as one, effectuation date of a contract. That is when the obligations will commence. Now, you will notice that the obligations need not commence as soon as the parties to a contract have signed the contract or have agreed to the contract. They can actually fix a date which is different from the date of the signature of the contract. So they will say that the contract may begin at X date, and that is the effectuation date wherein the obligations of the parties in the contract will commence. Second, you will notice that every contract will have an expiry date. Now, interestingly, in modern types of contracts, you would say that the contract is valid for 2 years, 3 years, or 5 years. And that is when the contract may expire, which means the obligation between the parties will close at the end of 2, 3, or 5 years. Having said all of these, you will notice that while parties have the freedom of contract to agree to the effectuation date and the expiry date, very often than not in modern day contracts there can be a continuation of the contract. That's also possible. So these are certain things that the parties in between themselves can agree to. However, the Indian Contract Act 1872, which is the foundational basic law, does speak about the aspects on which these obligations that have been entered into the contract can actually get terminated. Now, interestingly, contract establishes a legal relationship, and the legal relationship is not lifetime. It has to end at some point of time. So when will it end? Say in a sale of a property, it will end when the buyer has got the house and the seller has got his price. This will probably terminate the obligations between the parties, and the term vinculum juris means it is a legal bond. Right? Contract creates a legal bond, and the legal bond between the parties can actually conclude at some point of time, and the relationship is no longer existing. So that is what we say. Discharge of contract is nothing but concluding of contract. Now, what are the various modes in which a discharge of a contract can take place? To be honest, friends, the first and the foremost is discharge of a contract can take place by performance of a contract. Very clearly, this is a very easy rule for us to understand, that if the seller has an obligation to perform by transferring the possession of the house and the ownership of the house. Now, that is what a sale actually means. See, the term sale means that there is to be transfer of the possession of goods, plus there should be transfer of title or ownership of the goods or of the property. And hence, when the seller performs his obligation, of course, he is going to be discharged from his contractual obligation. What more is left from the side of the seller to do? Similarly, the buyer can only be discharged when he has paid the complete and entire price to the seller, and if he has paid the entire price, he has actually performed his part of the contract. So, performance of a contract is an interesting idea on which there could be a discharge of contractual obligation. However, you will notice that there are some challenges of this performance which we'll probably take up immediately after the slide. For example, what should be the time of performance, where should be the place of performance, who can perform. That's the most interesting part of the whole story. And can there be a responsibility between joint promisors who say are two brothers, right? Who should then perform the contract? So I think there are certain critical issues which the Indian Contract Act has addressed and given clarity, and there are some very interesting cases for us to decide whether by performance can you claim discharge. Second, of course, if performance does not happen, or if the parties do not fulfill their obligation, then of course the contract may be breached, right? Breached by either the seller or the buyer or by both the parties. What is breach? Friends, breach of a contract is the non-performance of a contract. Breach of a contract is non-fulfillment of the promise by the contracting parties. Breach means non-fulfillment of the obligations that have been accepted to be undertaken by the parties. So that is a breach of the commitment, breach of the bond, breach of the legal obligations that has been agreed by the parties. If they actually commit a violation, then we say that amounts to breach of contract, right? So in case the parties have committed breach, then please note, in contract law, as per the principles of equity and principles of common law, you have contributed to a fault, right? So you have committed breach, you have contributed fault. And once you have contributed fault, the court is not going to protect your interest or your right, because a party who has committed breach or fault is not to be entitled to the protection of the courts, is not to be entitled to the protection of law and equity, because it's like we say, we have an interesting doctrine called the doctrine of unclean hands. Yeah. So unclean hand means a party who has contributed to the breach or to the fault, and he has done so deliberately, intentionally, and knowingly that his non-fulfillment of the obligation that has constituted breach may actually injure the other party. It may affect the other party, and that is something we say is the doctrine of unclean hands. Anyhow, breach of contract is also interesting, and hence, when you say breach of contract, you will obviously have to evaluate what is the consequence of the breach, right? That is something that we will also have to take into consideration as well. The third ground, and this is a very important one and an interesting one, and as we speak in current times, especially in the post-pandemic kind of economic world, and pandemic being considered as as an activity that has affected contractual performance, Section 56 of the Indian Contract Act states that you ought to perform, but at some point of time you may not be able to perform, and it will be impossible for you to perform. Now, if it is impossible for you to perform, there cannot be expectation of performance at all, and if there cannot be performance, obviously the parties must be assumed to have been discharged from their obligation, right? So the contract has already been formed. Okay, so it has been done, say, 3 days back. Now is the time the performance of the obligation is supposed to happen, the fourth. Unfortunately, there are certain factors that affect my performance and make my performance impossible. Then in those circumstances, I cannot perform, and by performance, I cannot claim discharge. However, the law says, as an excuse of impossibility of performance, I can claim discharge of the contract, right? So the parties are supposed to perform, right? That is the rule. You can only get discharged by performance. The exception is sometimes because of impossibility of performance, you can claim discharge of a contract as well. Now, the interesting part here for us to appreciate is, in India, we follow the rule of impossibility. In common law, this is broadly brought about under a doctrine called doctrine of frustration, right? You are frustrated from performance, and hence the law gives you an excuse from performance. That's a very interesting, theory on the doctrine of frustration and how it applies in India. The doctrine of frustration seems to be quite broad. The rule of impossibility probably looks a little narrow, but I think these are certain of the issues that probably we'll have to discuss and take it forward as well. Then you have what we call as discharge by an agreement. Now, interestingly, what you have to understand, friends, is that when you talk about discharge by an agreement, sometimes the parties can actually lower the performance or the obligation expected. The best example I can give you, what we call as discharge by agreement, is, say, coming out with an out-of-court settlement, not going to the court and saying, okay, look, you have performed this, but okay, fine, I will forgive you, I will not file a case. So there is something called an out-of-court agreement to sue each other, right? So it could be any kind of an agreement where the parties do not want to extend or continue with their obligation, and by agreement they say, okay, we have been discharged. But the classic example that we can understand in terms of discharge by an agreement is the fact that very often than not, when you take a loan from a bank, sometimes the banks may open up this for negotiation, and they may say, look, there has been a default, you have to pay principal plus interest. However, we can enter into an agreement where you just give the principal and we will allow you to claim discharge of the contract, right? So here is where the bank may actually give you some kind of leniency, They may enter into a new agreement on the debt. They may not enforce the debt entirely with principal and interest. They may actually say, just pay the principal or pay an X amount, and we will say let it amount to a discharge of contract. So there can be a subsequent agreement to the original agreement where discharge of parties to the contract is agreed upon. So this could be one other basis of what we call as discharge by an agreement. We call it discharge by alteration sometimes as well, right? Agreement, alteration, and novation. These are three interesting elements that has been defined in the Indian Contract Act. Right, there can be alteration of the performance, right? So that is also possible, right? The actual performance was expected to be A, and I alter it, creating the new realistic scenario in place. It could be change of technology, it could be change of expectations, it could be lowering of quantity, the quality expected from the product, and there can be some kind of an alteration. And once I fulfill that altered kind of an obligation, I can claim discharge of a contract, right? So contracts are not sacrosanct in the sense that once you enter into the same contract has to be done at the stage of performance of the contract. The parties on their mutual agreement, and this is completely mutual. The parties have the trust. They continue to hold each other in good relationship. They want continuity of their business, and hence they can actually make some kind of a adjustment. And please note, today you have a lot of these adjustment clauses in modern day contracts, including what we call as the price adjustment clause, right? So there can be a new kind of a price adjustment that can be agreed, and the parties can claim discharge of a contract. Also, there is discharge by novation. Now, this clearly tells you that novation is a kind of replacement of the parties in the contract. So, suppose A and B agree to make a contract. Later on, B says, instead of me, C will perform the obligations in the contract, and A agrees to the same. Then in those circumstances, this is an act of novation where C replaces B, and then C is expected to perform to A. When this happens, please note, B is discharged from the contract. Why? Because it has been mutually agreed. A is okay. He can accept the performance from C as well, and this is something that has been agreed with the parties, and hence performance by some third party is now novation, and B can claim discharge of contract. So this is also a kind of possibility that the Indian Contract Act provides for. Finally, sometimes discharge of a contract can happen by operation of law, and we have to understand when can such a kind of discharge happen. It can happen especially when we are talking about, say, insolvency, bankruptcy of companies, or death or unsoundness of individuals as well. For example, if you relate by operation of law, please note that the law imposes a condition saying based on this ground, you can claim discharge. That could be something very related to what we call as impossibility rule as well. Let me give an instance or an example. So, if suppose I am a doctor and I have agreed to do a surgery on you, and the doctor dies before the surgery. Now, by operation of law, death automatically terminates a contract, especially in those kinds of contracts in which there is a contract of personal service. Now, please note, what is a contract of personal service? It means it's a doctor, it's an artist, it's a lawyer who have agreed to give you certain kind of service, which is based on their skill, labor, and qualification. And you cannot have succession to that contractual liability by, say, the son or the daughter or the wife, simply because it was the doctor's skill that you were dependent upon. In those circumstances, I think the family members of this deceased doctor can claim discharge based on death as being grounds for termination of a contract, and by imposition of the operation of law rule in which the discharge of a contract has to be expected. So I think it's quite logical for anyone to appreciate the same, but because sometimes parties may take this matter to a court of law, that is the reason in law we have these grounds to claim discharge of a contract, and legally that is permissible to claim discharge of a contract as well. Now, for example, let's take the rule of unsound persons. Now, unsoundness of mind, friends, is an important qualification for you to make a contract. But as I told you in the past, there is something called the lucid interval kind of a doctrine. And lucid interval means that at some point of time you are fine, you're sound, but at some other points you are unsound. So, at the stage of performance as well, it could be possible that the person whose personal services in the contract are sought, he has turned now unsound or he is not stable. And please note, today when I say unsoundness of mind under the Mental Health Care Act of 2016, unsoundness, mental health, we have changed the kind of perception that we want to talk about it, because Mental Health Act also makes depression as a mental illness, especially the extreme form of depression. So if I am a doctor and I am depressed, do you expect me to come and do the surgery? Obviously not. So these are circumstances in modern day context when a discharge of a contract without liability. Now, please note, discharge can have two consequences. Either you are exempted completely, you are excused completely without any responsibility, but at certain circumstances, you may have certain responsibility towards the other party. For example, we say, what is that responsibility? Now, let's assume that the doctor had already accepted an advance money for the surgery. Please note, the next of kin cannot say, okay, the doctor and his family are discharged, but we can go on to retain that advance money, because the law of unjust enrichment will apply in those circumstances. So you can claim discharge provided you do not do unjust enrichment, you give back that money to that other person. Obviously, I think the other person can go to any other doctor and do the surgery. However, the family here can claim discharge of a contract. So what does discharge do? The consequences is that the legal relationship between both the parties ceases to be in place, and nothing more is to be done between both the parties. That is what the logical sequencing of discharge of contract does, right? So we say it is termination of the rights and obligations that arises between the parties, and that is an element that discharge comes or falls into place. So friends, if we go forward in understanding discharge of contract, and broadly if you try and distinguish it between discharge by performance as against discharge by breach of contract, because these are two contradictory grounds on which discharge of contract takes place. So if you apply it to government contracts, you will notice that one will have to perform his obligations that he has accepted, say in the purchase order or in the agreement that is being signed between the government and the contractor, or else he is liable to the allegation that he has committed a breach of contract. Of course, when a breach occurs, then the next question is, any party who has been aggrieved by that kind of a breach has to be given remedies under law. So the law on damages and the law on specific relief are the kind of remedies that we would want to look forward to. However, if you look at performance trends itself, the law has divided performance of a contract into the challenges of performance that usually are kind of visualized, which can be foreseen in contract, in reality of the contract. So interestingly, performance of a contract, it's like satisfaction of a contract, right? So if you're performed, I need to be satisfied. But I'm sure as consumers, we can probably relate this to our own instance, that performance is a challenging factor, because the expectations or the mismatch of expectations, as the case may be, always don't meet. They don't agree to the same thing in the same sense. Because see, performance, you'll have to probably have some criteria to evaluate the performance sometimes. Now, in product contracts, you notice that performance is, say, from a consumer perspective. Now, for example, you buy a telephone or a mobile phone. Now, the performance are something that are being described when the phone is being sold to you. But, again, as a consumer, when you're actually using the phone, you may actually say, the performance is still not up to my expectation. Right? So the expectations of performance usually from the receiver are always a challenging factors in contract. This is so very easy to probably narrate in terms of product contracts as against service contract, or even as against what we call as works contract. Now, when I say service related contracts, you will notice, friends, let's just assume it's human resource service related contracts. For example, we may be outsourcing the security guards or any other kind of services of a gardener or a computer software engineer. So many of the services can be. So over that, performance is on a day-to-day basis. It's based on certain kinds of expectations of the other party, and it may depend upon individuals. So the performance always has been a challenging factor. For example, works contract. Again, there are so many challenges of what is actual performance, right? You are constructing a building, or you are constructing a road, or you're constructing any other kind of infrastructure work. How do you rate the performance? Now, people may rate it at a scale of 5. A 5-star rating is obviously absolute performance, but usually you will notice that people have challenges of performance. There are disputes that may arise during that performance stage as well, in terms of saying, look, my expectation was X quality and you have delivered Y quality. My expectation was 110% performance, you have probably given 90% performance. So performance has been a challenging factor. Very easily said that it amounts to discharge, but actually at the stage of performance, it might be difficult as well. For example, we say performance in educational, coaching centers, or educational softwares like, say, Byju's, Vedanta, and others. See, what is the performance of the kind of services that you bought over there? Is it based on the kind of marks that you score? Because see, the marks that you score is dependent upon your learning abilities and your performing in the examination. How is the coaching institute to be blamed for it? But again, they have said, look, we will assure you this and that, and we have probably substantially delivered it. So performance is something that they would always claim that we are okay with it. We have done it. But the other party may say, okay, it's not as per, say, industry expected standards. Right? That's something that is a usual kind of a defense against non-performance, or lack of performance, or deficient performance. The word deficient performance is always very important, because again, it is based on that kind of mismatch of expectations. So you have the performance, but it's not as per your expectations. Can you still claim discharge of a contract? Right. So I think the rule that you see in Section 37 of the Indian Contract Act is a very important rule. It allows parties to claim discharge of a contract based on a rule called what we say substantial performance. Right. Now, substantial performance is a good ground if you have done as per, say, industry standards, as per standards that any other service provider is expected to do. I think based on substantial performance, you can claim discharge. So substantial is not in terms of percentage of saying, oh, does 90% amount to substantial performance? If I complete 90% of the work and not 10% in, say, a works related contract, you cannot claim substantial performance, right? You have to complete 100%. So it's not on the percentage mark, but it's on the fact that, look, quality, or say expectations of performance, always vary from person to person, from time to time. Today, let me tell you, in terms of public works, suppose a contractor lays down. See, the government department may say yes, he has performed, but citizens' expectation of performance has definitely increased, isn't it? And hence, citizens expect roads to be very good, infrastructure to be robust, of international standards. So today, standardization in India has changed the perception of kind of performance that is expected. And we say performance without defects, performance without any malfunctions, or performance without any deficiencies, performance without any kind of parameters wherein people can judge that yes, this is a defect in the performance. So substantial performance has been a ground for some time, and it is there from 1872 in Section 37. It's a great defense. It all depends upon how you would probably state the issues on substantial performance. But yes, that is one element as against non-substantial performance, which may not amount to discharge of a contract. Impossibility of performance, of course, this is a claim. We'll probably talk about it a little later, but I'm just telling you the different aspects in performance that may be critical to judge, to decide whether it would amount to a proper discharge of a contract. One other very interesting dimension that has been introduced today in 2018 by the amendment to the Specific Relief Act is a kind of performance which is called substituted or substitute performance. So substitute performance, friends, is where I don't have any more trust in you that you will perform the contract, so I replace you with someone else. Right? Now, ordinarily in most government contracts, this is called the risk and cost purchase clause. Risk and cost purchase clause. So in most government contracts, this this has been in existence, which clearly means that, look, government is all about public services, it is about public civic amenities, and so on and so forth. So if a contractor who has agreed to make a project or an infrastructure kind of a work, he does not, or he is unable to, or he delays the whole purpose of performance, then the government reserves the right to actually replace him with somebody else. That is what is known as substituted. So instead of you, I'll get it performed from someone else. That is what substituted performance actually means. But interestingly, this was a clause in a contract most often than not in government contracts. But today, in 2018, you will notice that this has now been brought as a relief. A relief that can be exercised by the parties, and it can be vetted by the court and said, yes, this is the right way of doing things. Because remember, if one fails to perform, then there are certain remedies that the parties can exercise, but most often than not, these remedies are they postpone the performance of the contract. You may get damages, you may get money or monetary compensation, but the work itself gets suffered. And in government contracts and infrastructure projects, friends, when work-related aspect suffers, it is the citizens who suffer, right? So, of course, in infrastructure contracts, if one person is unable to do it, yes, we will decide the dispute later on. What is the dispute? What is the problem? What are the challenges? It will take 3 or 10 years time for an arbitration of the court to actually say who is right, who is wrong. But in the meantime, the work should be completed. So if this contractor is not completing it, let us get it done from someone else. Let the work get completed. The dispute can take its own time to be adjudicated upon. And hence, performance replacement is what substitute performance is. If my contractor is unable to do it for X, Y, and Z reason, including the plea of impossibility. So he may come and say, for me, it is impossible. It's possible, right? He may say, okay, the impossibility rule, I should be excused from performance. He may definitely claim it, but I'm sure anyone else who is willing to do it and who can actually probably replace the performance. Of course, in government, it's not about making a call about, yes, I need a replacement and someone else must substitute. It is also about evaluating whether that someone else is equally good enough to complete the work, right? So that kind of a evaluation the government will obviously have to do. But yes, this is a remedy under the specific relief act that you have the chance of getting the work substituted and performed by someone else. This is an option. This is a relief that you can exercise. And please note, this is a self-remedy. It's a remedy that you can exercise on your own self under Section 20 of the Specific Relief Act. Of course, if the matter goes to the court or the challenges goes to the court will have to probably just say, yes, I think the grounds on which they have exercised substituted performance is valid or invalid, right? Of course, if it's invalid, because see, very often they're not in government contracts. If suppose the contractor and the government officer are not in good terms, then if you unreasonably in a mala fight intention, if you have not had the valid grounds to exercise substitute performance, of course the government and that department could be held responsible for a breach of contract, because the existing contractor would have agreements that his rights have been infringed by an unreasonable, unlawful exercise of substituted performance, and based on that breach, he can also claim damages. But this is one very interesting dimension to the aspect of performance. Finally, yes, performance is important, but time is the essence of every contract. And time being the essence of every contract, please note, performance has to be as per that kind of a time. So the Indian Contract Act very clearly says time and place. Please note, time of the performance and place of performance are very, very critical. They are very, very important. So you cannot claim discharge of a contract if you have performed beyond reasonable time, if no time is agreed upon, right? Reasonable time is always ready to contract, one. Or if the time is fixed and you do not adhere to that time, it is a case of delayed performance. And delayed performance, friends, is no performance. I repeat, delayed performance is no performance. The other party has a right to either reject your performance or affirm that delayed performance. If he affirms it, it is like he's saying, okay, हमने माफ कर दिया आपको. You can go ahead and continue to perform the obligations in the contract. I'm willing to pay you, and I will perform my obligations. So that's what we say is like, you affirm a delayed performance. That's a choice, but it's a discretion of the other party, and hence delayed performance is actionable, and that is something that Section 55 clearly stipulates as time being the essence of the contract. And any kind of delayed performance or displaced performance. Now, when I say displaced, I'm just saying this as place being the essence of the contract. right? You cannot perform anywhere else and say, okay, performance is done. You must perform where the other party expects you to do or perform the same. Like supply of goods, where does he expect? Probably in his own factory or warehouse. You can't then say, oh, I've dumped in the city, bus stand or railway station, you pick it up from there. No, that's not performance. So I think the parties must understand time and place of performance becomes very critical, though there is performance, unless it is done in the appropriate time and appropriate place. Performance as a matter of discharge of a contract cannot come into existence. Now, coming to the breach of contract, friends, please understand. So, if it's performance, fine, that's discharge. If there is no performance, it is breach. When do you say that there is breach? Friends, breach is when, please note, the time of performance has come and no performance has been expected. That is when breach occurs, right? Because time was the essence of the contract, it was mentioned in the contract. So that's an actual breach. If you have not supplied at the day on which you have agreed upon and the goods don't arrive, that's a breach of contract. Second, the place of performance has been mentioned and you do not perform it at that place, that is also a breach. So that we would say is an actual breach. Actual breach is where the party either communicates or fails to perform his obligations in the contract at the time and place where it was expected to perform. That's what a breach of contract actually means. So failure to perform, unable to perform, excuses of performance, non-performance, all these will amount to a breach of contract. However, as against actual breach, there is this very interesting proposition of what we call as anticipatory breach. Now, anticipatory breach is a kind of a breach where you as the buyer very clearly understand. It's not based on just a mere suspicion, but you clearly have evidences and understanding saying that the other party on that time and date will not perform. You have that information. You are very convinced that the performance will never happen at the given time and the given place, and situations are such that the seller is probably already made a contract with some third party, so the buyer knows all of this, right? So why should he wait for the date on when the sale agreement is to be executed? So he will say, look, I'm anticipating breach. Okay? Now, the anticipatory breach suit can be filed in India. It is provided in the CPC as well as in the Indian Contract Act that you don't have to wait when the actual breach happens. You don't have to actually postpone your remedy. You can actually go to the court and say, look, I know that the seller has already made a deal with some third party. He is actually offering the same house that he has offered to me to a third party. And I anticipate that, when the date of the sale agreement is to be executed, he will not exercise that kind of a sale. So in anticipation of his breach, I am coming to the court. Please give me remedies. Now, one of the interesting and most important remedy that is given in anticipatory breach is injunction. Right? You want to stop the seller from dealing with some third party or offering the house to sale on some third party, accepting some consideration from that third party as well. So in anticipation of the kind of loss that you as the buyer may suffer due to the misdeeds of the seller or due to the kind of adventurism of the seller to actually commit or do some kind of breach, you would want to go to the court, and you want the court not to create that kind of a loss situation for you and then give you the remedy. Rather, you want to abate the kind of loss that you can anticipate from a kind of a prospective breach of the contract. So anticipatory breach is before the time and actual breach is after the time. So that's the distinction. And interestingly, in both of these elements, because there is a promise and there is an anticipation that the promise will be broken or breached, or the promise has been already actually breached, you can actually go to the court in both these two circumstances. And interestingly, you will notice in either the case of suit of anticipatory breach as against actual breach, the remedies don't differ. You can claim all the remedies in both these two cases. The only thing is the concept very clearly tells that you can approach to the court before time as well, right? And you don't have to wait for the actual loss to actually start occurring. Right? There are remedies that you can lessen the loss, get a faster remedy or a relief, and the courts may probably come to your rescue as well in a suit of anticipatory breach. So that's a very interesting aspect, and one will also understand that today for breach of contract there are different forums that are available as well. So it is about which court you would want to go. For example, friends, in most cases of, say, an anticipation of breach in the contract itself. Now, what do I mean by this? See, when you make a contract, you make that document. Actually you don't need the document, right? You expect the other party to always fulfill your obligation. Why do you make a contractual document? Because you anticipate maybe there could be a breach. There is a risk that the other party may not have. So we make a lot of clauses that protect the rights of the parties in case a breach occurs, right? So none of these clauses, none of the words in the contract will actually be required if the performance is done by trust and confidence of both the parties. The contract paper will go to the dustbin. But then, if one of the parties decides to commit a breach, then the clauses in the contract will start coming to force. And that is when, you would want to encash bank guarantee, you would want to claim liquidated damages, so on and so forth. But the point is, see, today, thanks to the Arbitration and Conciliation Act of 1996 and the various amendments that have also followed under this legislation, one of the options that the parties can exercise, please note this is the freedom of the parties, that they need not go to the court. If they wish, naturally the courts have a right to review every contract, to adjudicate any disputes arising from the contract, and to grant you relief under specific relief act. So the courts are the judicial review for breach of contract. However, the alternate is you can also go for alternate dispute resolution. So interestingly, friends, today in most of these contracts, arbitration clauses are a very prominent clause, right? So people say, if there are any disputes or any differences that arise between the parties, the matter can be referred to arbitration. We either say sole arbitrator or a tribunal of 3 arbitrators, because the law says you cannot have you should only have odd number of arbitrators and you cannot have even numbers of arbitrators. Interestingly, friends, if you look at arbitration, this has become a very, very formal way of dispute resolution in commercial matters. See, arbitration generally is divided into 2. You can have statutory arbitration like in the Cooperatives Act, or you can have arbitration for commercial matters. Commercial means contractual issues. So we are talking of arbitration in a commercial context, right? So you will notice that today an arbitrator is like a court. Now, if you look at the Arbitration Act, an arbitrator has almost all the power that a judge has, literally, right? So it's like, we want commercial disputes to be settled faster and outside the court because it's private law. And let the parties refer the matter to arbitrators. Arbitrators can be former judges, they can be experts in that particular dispute, financial or otherwise, and hence the resolution of the dispute can be in a time-bound manner, and the business will not be affected because of delays in the court and court system and etc. etc. So arbitration very clearly gives you certain very distinct advantages as against the court, and the parties have the right to refer the matter to arbitration as well. Importantly, you will notice that today the interesting matter is you can also have conciliation. Right? Instead of having a formal dispute resolution matter, you can have a conciliation where the parties themselves want to voluntarily resolve the dispute, and hence conciliators can help them arrive at how the gap. Dispute is nothing but a gap. So how do you bridge that gap? Right? And can there be some give and take so that there is continuity of business relationship? And conciliation could be another form in which dispute resolution in commercial matters can actually happen. However, you will notice the new or the latest way in which, and this came from the UK precisely because there is a law in the UK already, that in construction contracts, you can have a dispute review board. This is called the DRBs. And the dispute review boards can be, kind of a regular, kind of a 3-member panel, which can actually be referred with certain kinds of major or minor, kind of differences of opinion between, say, the builder and the contractor. So, because in construction matters, please note, it's a long-term contract. It is, it can change in between sometimes because of the design of the architect or the expectations. There could be newer and better, say, sanitary, plumbing, furniture, and so on and so forth. So that kind of adjustment may be required in construction contract, and hence why should we have just an arbitration clause for referring to a one-time dispute or going to the court as being a one-time dispute? Rather, you can have a regular 3-member or 1-member kind of a board which can actually resolve some of these minor issues from time to time, so that the construction continues and the business relationship does not get stalled or adversely affected as well. So these are possibilities how the breach can be addressed in the court as well. Of course, injunction under the Specific Relief Act are of three types. There is temporary injunction, there is permanent injunction, and there is mandatory injunction. That is something that is provided in Section 36 of the Specific Relief Act and onwards, right? Temporary injunction is at a very preliminary stage. You just want a stay order. You don't want things to go bad and go worse. You don't want the other party to continue what he was continuing, and hence you take a temporary injunction. Later on, if you want the temporary injunction to be converted as permanent, that is when, after merits of the case, after hearing and arguments and evidences, the court may convert that and say permanently you will not enter the premises, or you will not engage in the other party, or you will not disturb the rights of the other party, something that they can always grant in the court of law. Then you have mandatory injunction. Interestingly, what is mandatory injunction? It's a direction of the court to actually say to a party, you should probably do this, and this is what is right, and the court has decided that this is what has to be done by you. Please go ahead and do it. If you do not do it, it's a violation of the mandatory injunction order. So mandatory injunction order is like an order of specific performance. See, you ought to perform, right? You cannot do away with that kind of specific performance, which is also a remedy under the Specific Relief Act. Specific performance of a contract. What you have agreed, you ought to do and nothing else. So specific, right? All the obligations agreed by you have to be performed, and there is no escape route out of it. You cannot run away by just paying some damages in money, but you are obviously bound to do what has been agreed in the contract. So that is one way in which mandatory injunction looks like. Interestingly, that's what Section 14 says, specific performance of a contract. Specific performance of contract today, if you read the Specific Relief Act, which has been amended, is a rule, right? Earlier, it was a discretion of the court to grant specific performance, but now under the 2018 kind of an amendment to the Specific Relief Act, specific performance has become a rule. Yes, that parties that have agreed to do certain kind of an obligation must perform whatever they have agreed specifically. No other remedy is going to be equivalent or is going to be adequate enough. And what has been agreed must be done, and no other kind of remedy should be entertained by the courts of law. That has now been made a rule, right? So I can go to the court and say, he has to complete the work. I don't want anything else. I don't want any other remedy. And which could be the other remedy that generally we speak in terms of breach of contract. We talk about damages. See, damages is always given in breach. But see, when damages are given, it is done in terms of money, right? We say damages is from damage. So you prove damage, you will get damages. It is the monetary quantification of the loss that you may have occurred due to the breach. So people used to find it very easy paying that money and running away with breach of contract. Because in India, there is nothing like a penalty kind of damages that is being offered. It's usually nominal damage. So people found it very easy to pay money and escape their obligations in a contract. Now, to remedy that, I think the change was brought into 2018, and we said, no, money should not be the primary factor of giving in breach. First, evaluate whether specific performance can be granted in the contract, and if it can be granted, that should be the first remedy. If not, then other remedies can follow. That's how I think the law has to be read right now. So a party can be forced to complete his obligation in the contract, and he cannot be allowed to escape just by paying the monetary compensation or loss. However, you notice that while specific performance is rule, of course there ought to be exceptions of the rule as well, because in certain cases you do not want to force a reluctant party to commit the performance of the contract. Right? He's already a reluctant party. That's why he has committed breach in the first place. Otherwise, he would have completed the work, right? And second, you have already sued him in the court of law, so there is some animosity between the parties. So there is no point in forcing him to perform the contract. But the real challenge of specific performance, friends, it is easy for the court to order specific performance, but once that order is passed, the party may start performing. Right? He may go to that place of the contractor or the government office, and he may start performing the contract. Suppose once he starts performing the contract, because of the kind of animosity, the dispute, the conflict between or differences between the parties exist, imagine what quality of performance he can give. Right? Then you will again come back to the court and blame that, look, there is a quality problem, there is a efficiency problem, and so on and so forth. So then the court again has to then judge the quality and the performance. So it becomes kind of a continuous monitoring or supervision that would be required from the court if they grant specific performance of contract. That may not be the right way of probably dealing with the whole situation. And hence you will notice that where the courts find that the party is not competent enough any longer, it does not have the intention any longer, monitoring and supervision may be required, and there is no point asking such a reluctant party to go ahead and perform, because tomorrow it will result in a lot of safety issues as well, right? So in those cases, I think the courts have the discretion of saying no specific performance, just give damages as well, right? And specific performance of a contract cannot be insisted in a contract of personal service as well. Say a doctor, you cannot force a doctor saying yes, he agreed, he did not do the operation, now please force him to perform the surgery. Now it's very easy for the court to say yes, the doctor must perform his obligation, but he is a doctor. Now tomorrow, if there is a force from the court, because there is a remedy that is provided, you can imagine what kind of operation or surgery the doctor may actually commit, and how it may adversely affect the rights and interest of the patient. So in some of these contracts of personal service, specific performance of contract must be avoided and not must be granted, because it may create a lot of difficulty for the legal system to observe, monitor, evaluate the kind of performance, and this will only result in multiplicity of litigation and suit, and it would result in a lot of challenges as we go forward. What is important is also about who can seek specific performance of a contract. Please note, it's only the other party generally who can seek specific performance of a contract in a court of law. But remember, the law provides for certain other kinds of people also to claim specific performance of a contract. For example, I die and my son wants to seek specific performance of a contract. He has that particular right. So in terms of succession, people who succeed to contractual rights also can seek specific performance of contract. Second, promoters of a company. So the company, is expecting some performance from someone, but the company still has people as in the role of a promoter, and the promoter can go to the court and ask for the remedy of specific performance from that party towards the company. So promoters have that kind of interest in the contract, and because they have the interest in the contract, they also can go ahead and seek specific performance of a contract. So the law provides for a lot of parties to seek specific performance of the contract apart from the signatory to the contract. For example, agents. Now, the contract may be signed by the principal. Can the agent go to the court and seek specific performance of the contract? The answer is yes, because he is a person who has some interest in the contract. He's a beneficiary of the contract in some sense, and these guys also can go to the court and claim specific performance of a contract. Now, coming to the kind of remedies for breach of contract, you will notice, friends, that we do have certain kind of remedies, and you can probably divide them into three categories. These are not the only ones, but just to give you a highlight of what these kinds of remedies for breach look like. First is damages. They are divided into two kinds of damages, liquidated and unliquidated. Section 74 deals with liquidated. 73 of the Indian Contract Act deals with the unliquidated damages. Practically, you will notice this is called LD sometimes, that is liquidated damages, and it has a huge law. We will probably deal with that when we talk about common contracts in detail. Then, bank guarantees and security deposits. This is very normal in terms of tender notification. You take what is known as performance bank guarantee at times. So we will deal with that also. And then you have this incentive versus penalty clause. Penalty clause, is invoked usually when there is a fault and when there is a breach beyond the time, and incentive is when you complete the work before time. So, you find certain of these government contracts which have an incentive clause. So if you perform before time, then you are eligible to that 5%, 3% incentive that can be additionally given to you beyond the contract price. So I think that is also a remedy sometimes that can be provided for performance as against breach. Taking it a little bit forward on trying to understand discharge by performance, one would notice that Section 37 of the Indian Contract Act says the parties to the contract must either perform or offer to perform their respective promises at the time when the performance of the promise is expected, unless such performance is dispensed with. Dispensed means the other party doesn't wish to take a performance, or is excused under the provision of this act. When I say excused, friends, I did tell you about Section 56, in which you may be excused from the provisions of the performance due to impossibility. Or please note, very interestingly, it says you may be excused from the performance of a contractual promise or of any other law, right? So it could be under, say, the Essential Commodities Act, where the exchange of performance may now be regulated, permitted, restricted, and so on and so forth. So there could be special legislations due to which the performance of the contract has not been something that you can go ahead with, or is not legal, or is restricted or prohibited, right? Any other law, right, apart from the contract law, which can actually affect the performance of the contract. So I can give you one example of this, of any other law for the time being, is like, see, at one point of time, sale of lotteries in Karnataka were legal till a law was passed to prohibit the business and sale of lotteries. Now, the contract would have been made, and after which the law banning sale or exchange of lotteries coming into existence, the performance of the lotteries may not be possible because of any other law trying to affect the performance of a contract. So, in that context, Section 37 becomes very critical and important as well, right? So, another aspect in Section 37 that one must note is about trying to perform or tendering performance. I think tendering your part of the performance is very critical and important for you to claim discharge. If after you tender, the other party does not accept the tender or does not provide a place for performance, or has dispensed or excused that performance, then to that extent you can claim discharge of contract. What is important over here is who can perform and who is expected to perform. You will notice that when contracts are made and promises are exchanged between the parties, they bind the representatives of the contracting parties, that is the promisor and the promisee. So in certain instances, you will notice that legal heirs or the next of kin of the family members of those who have actually made contracts may be responsible for performance of a contract, unless there is a contrary intention that appears either from the contract, or it would depend upon the kind and type of contract. As I told you earlier, if it's a contract of personal service, it will not bind the representatives of the promisor at all. But in the rest of the other contracts, performance may be expected from the legal heirs, from those who inherit property, and hence they may be responsible to tender performance or perform unless it is dispensed or excused with. Now, if you look at it, the legal consequences of performance is the discharge from the obligation created by the mutual profits, and hence this becomes very, very important. And once you have completed your performance, then the liability comes to an end. So you are no longer liable for that performance. However, contract definitely has performance from, most contracts have performance from both the parties. If I have to do something, the other person may have to pay the consideration of the price for the same. So performance is actually a mutual kind of a rule that usually the parties in normal circumstances can expect mutual performance. So if I do this, I expect you to do this simultaneously. So it is mutual, it is simultaneous, and it binds both the parties to a contract. So readiness and willingness to perform is very, very critical. In many circumstances, you will notice that your readiness and willingness will be very, very important for the court to judge whether you are clean and whether you can be, given the remedies for breach in case the breach happens at a later point of time. And hence, when parties to a contract want to ensure their performance, either they perform or they express their willingness and readiness to perform the contract, and that is, I think, an essential basic requirement as well. Most contractual performance will depend upon the skill of the parties, and hence you will notice that unless the skill can be acceptable from any other individual, the party who has agreed for the performance, he himself must perform, and he cannot delegate the performance to anybody else. Right? So delegation of performance is not possible. However, you will notice that the Indian Contract Act definitely stipulates the fact that you can actually employ a competent person to perform the contract. So for me, he should be competent. That's inevitable. However, for the other party also, he should be convinced that if there is some kind of a delegation to a competent person to perform, that it will not compromise the expectations from the contract and from the kind of performance that is expected from the contract. So that is very, very critical. Hence, you will notice that either the party who has made the promise must perform, or he can employ a competent person to perform, or the performance can also be expected from joint promisors. Say when there are two or more parties to a contract who have promised to make a performance, or it could also be that the joint promisors could be partners in a partnership firm, or it could be two brothers who are co-parsonees who are making this kind of joint promisor, or it could be two individuals who are part of, say, a consortium bid. Consortium bid is where one person actually ties up with another company or another individual, and they both together actually submit their bid for seeking government tendering and contract. So in those circumstances, the principal rule in those cases is the joint and several liability principle. So if one party does not perform, the other party is bound to perform. So that principle will definitely be applied in case of joint promisors as well. Now, what are the conditions of performance? Now, this is very important, friends, that if you're performing and if you think that you want to claim discharge from a contract on the grounds of performance, then you are responsible to discharge certain obligations of duty that may be compelled by law. For example, the law says that performance should be unconditional, right? So, however, was the obligation that was accepted in the contract, the performance must fulfill those same obligations as it is. No new condition can be imposed for performance. No preconditions or any kind of new conditions can be added to the ground of performance. If it is done so, then it would be conditional performance subject to the acceptance of the other party as well. So performance has to be unconditional. It must be as it was agreed in the contract, and nothing new can be added at some point of time as well. So such kinds of conditional grounds of saying, if you do this only then I'll perform, that new condition will be considered subject to acceptance. If it's not accepted, imposing of such conditions may amount to a breach of contract. Yeah. So conditional performances or any additional conditional performances or imposition of preconditional performances may amount to a breach if the other party does not accept the same. So you are duty bound not to impose any new conditions, and that is critical in terms of understanding contractual obligations as well. Further, every kind of performance must be made by the promisor or his representatives. That's there in section 40. When I say his representatives, it means usually, a company can make a promise, and company cannot probably be a person of its own to make the performance. And hence, the agents of the company, which could be directors or even employees, may be expected to complete the performance. Or it could be in a natural person capacity, as I told you earlier, that the promisor himself may perform or expect some of his representatives to actually complete the performance. Third, I think performance must be made at a proper time and a proper place. I think that is very, very clear, and proper is to be subjective to the case. Now, there cannot be an kind of a law which says what and where the place is. So depending upon the contract, and generally, please note, when we say proper place, it means usually the place of the buyer, because he is buying the goods. So it's the duty of the seller to see that the goods are in a deliverable state, and it has to be placed at the buyer's disposal, and probably at a time when the buyer requires those goods. So usually when it comes to proper time and proper place, it is a buyer's perspective which the seller has to meet, and it is the customer or consumer perspective which manufacturers and producers have to meet. That's the kind of an implied rule, unless there are contrary intentions that are expressed in the contract. What is also important is that the promisee must have a reasonable opportunity to ascertain the thing that is offered, whether the performance is of a whole or a part. So which means that the buyer or the promisee has a reasonable opportunity to inspect the goods. Of course, he must be able to evaluate the performance. He must be able to understand the same. And hence you will notice that unless that reasonable opportunity is there, the performance will not be completed. So wherever the goods are delivered, usually say in the packaging material, you don't know whether the goods are proper or not. You may still certify it because it's in the packed commodity that you have received or the goods have been delivered to you. But the performance is not going to be completed unless the person is able to open the packaging material, see the product, test it, and probably view whether it is as per the performance as promised or not, right? So just by delivery of a packed material or delivery of things in which the promisee does not have a reasonable opportunity to inspect or ascertain whether the performance is completed or not, the performance will not be considered to be completed. A couple of cases on this point would be quite interesting for us to understand. This is the startup versus McDonald's case. In this case, a seller, he agreed to supply 10 tons of linseed oil. So that is what startup agreed to give it to McDonald's. And unfortunately, the parties said that the delivery must be done within the last 14 days of the month of March. This was what was stipulated in the contract. Now, last 14 days of the month of March, is it certain or uncertain is the most interesting question in this case. Now, startup delivered these 10 tons of linseed oil, and he delivered it on the last day of the 14th day of the March month, but he delivered it at 9 o'clock at the night, right? Now, is 9 o'clock an appropriate time? If you ask me, it's still the last day of the 14th day. So day ends only at 12 o'clock in the night. Now, McDonald's refused to accept it owing to the lateness of the hour. Now, the court in this case was to consider whether 9 o'clock is an appropriate time for performance or tendering of performance. But what the court said was, look, McDonald's was still in his warehouse. And this is something that was known to startup, that McDonald's operates his warehouse quite late in the night. Usually, you notice that most business hours is at 5 p.m., so any delivery or performance has to be done before 5 p.m. But in this case, McDonald's warehouse was always open. He was always there in his warehouse, even at those late hours, and startup knew it. And that's why he decided that, he would send these goods. But unfortunately, see, when 10 tons of linseed oil are delivered, the warehouse may still be open, but did McDonald's have the opportunity to take in the goods, weigh the goods, ascertain the goods, and then certify whether the performance is done or not? Unfortunately, that could not have been done, and hence, what startup did was he did not actually perform at the appropriate time, though it was at the appropriate place. And 9 p.m. was considered not an appropriate time, and hence the performance was not amounting to discharge of a contract, and startup could be held responsible and liable for breach of contract, is what was held in this 1843 case. FO's shipping company versus Paganan is another interesting case in which it was a ship by this name, FO's. It was supposed to be chartered by the defendants, and it was a chartered kind of a ship. And the due date for payment was 14th June 1978. Now, the defendants who had taken this ship as chartered instructed their bank to make payment by telex to the appellant because they had hired the ship. So the payment instruction was given to the bank. And on 13 June, the bank sent the telex, unfortunately accidentally, to a wrong address. And this error was discovered only by 19th June. On 14th June itself, the ship owners, that is the appellant, issued a notice of default to the defendants. Now, the court held in this case that the notice was not appropriate, it was bad, because the debtor had to pay before or after midnight on June 14th. So that was the date, that was how it was agreed. So if someone is sending you a notice of default on 14th itself, then that notice would not be appropriate. So time is the essence of a contract. What has been agreed, people will have to adhere to it. Otherwise, the court will not accept such kinds of notice of default or breach that was sent on June 14th. So, on 13th, there was tendering by the defendants, and they had instructed their bank. The bank also sent it, but unfortunately to the wrong address, right? So that was something on the part of the defendants. They had performed their obligation to see that the payment is done. However, I think there was some kind of urgency that was shown by the appellants, and they decided to send a notice of default on 14th June itself without waiting for midnight of 14th June to actually pass off. So it was kind of a hurried notice, and hence the notice was bad in law, and hence the defendant's kind of performance can be held to be valid because they had gone about doing their job appropriately. This Indian case, which is called Naveen Chandra versus Yogendra Nath Bhargava, it's a 1967 judgment. This was a case of a tenant, Mr. Naveen, who had rented a premises from Yogendra Nath, the owner. And Naveen sent 2 checks to pay his rent. Yogendra Nath rejected it. He said, no, nothing doing. I will not accept rent through check. So he was unable to, say that. Now, please note, tendering of performance is important because you have to actually pay the rent of the house by every month. And he sends 2 months rent through a check. And Yogendra Nath refused to accept it. He said, this is not what was agreed upon, and I will not accept the rent payment through check. And hence he rejected it. See, ordinarily, check is a good medium of payment. However, in this case, the parties were not businessmen, and they had very clearly agreed that payment through check is not acceptable. No, it is only through cash that was acceptable, and hence tenant actually defaulted. He defaulted by not making the payment as per the agreed mode, though he was ready to make the payment, right? So he had sent the check. So the check could have been easily encashed, but the landlord, as any landlord would want to be stubborn enough, he insisted on cash and he refused to accept the check, which means he was willing to ask Naveen Chandra to leave the house because there has been a default. And the court did agree with the landlord because that was the terms, the conditions of the contract. And once a mode of payment has been agreed between the parties, any other mode cannot be used, and that could be a conditional performance. And conditional performance are subject to rejection or acceptance, as the case may be. And that is the basis on which the court said that the defendant was entitled to refuse acceptance of the payment of the check. So, with these 3 cases, we understand that where performance is held valid and where it is not held valid, and we will, probably understand that the conditions laid down in the Indian Contract Act, especially from Section 38 to Section 49, are very, very critical. Parties must perform at the proper place, time, unconditionally, and they must tender those performance. If not, they shall be liable for breach of contract.